Prime Minister Andrew Holness is taking the Integrity Commission to court. Stay tuned. I'll have your breakdown in just a moment. I'm Dionne Jackson-Miller. Thanks for being here. Okay, so let's first of all be clear about what is happening here. The Prime Minister is asking the court for leave, for permission, to then apply for what is called judicial review. So what is judicial review? Judicial review is the power that the superior courts have, the Supreme Court, to review the decisions that are taken by bodies like the Integrity Commission to make sure that they are acting within their legal powers. So judicial review really is about making sure that a decision was made in the right way, that the process was lawful, the process was fair and just. It's not really about whether the decision itself was correct. It's about the process in arriving at that decision. All right, so let's look at what the Prime Minister is asking for. So I'm going to be going through the court papers with you, telling you what is in the Prime Minister's affidavit, that's his sworn evidence. Also, what are the many declarations and orders that the Prime Minister is going to be asking the court to make. I just have to make a point right at the beginning though and highlight something for you that is pretty surprising. The Prime Minister wants the court to make a declaration striking down the provisions of the Integrity Commission Act. He also wants the court to strike down Section 14(5) of the Corruption Prevention Act. Now, this is a section of the Act that deals with illicit enrichment, which of course you probably know is what the Prime Minister has been investigated for by the Integrity Commission Act. I'll tell you more about that when I get to that part of the document. I wanted to highlight this because it's pretty surprising to see a Prime Minister, head of government, a legislator, in fact, asking the court to strike down provisions of the Integrity Commission Act, which is the act that's put in place to help to fight corruption in the public sector, and also asking the court to strike out Section 14(5) of the Corruption Prevention Act, which again, the illicit enrichment provision was enacted to try to stem corruption in the public sector. When we get to it, you'll hear the details of why the Prime Minister wants the court to make those particular decisions, but let's start now at the beginning. Okay, so let me start out by saying who exactly is before the court. And before the court is Andrew Holness, the Prime Minister. Also before the court are 3 companies associated with the Prime Minister, and which you heard about if you watched any of the videos that I did on the investigation report from the Integrity Commission. The applicants in this matter are not just the Prime Minister, but Mr. Holness, along with Imperium, which is a company that's wholly owned by him, also Positive Media Solutions and Positive Jamaica Foundation Limited. Now, the orders are being sought against 2 directors of the Integrity Commission, which is Craig Beresford, the Director of Information and Complaints, along with Kevin Stevenson, the Director of Investigation, along with the Integrity Commission as a whole. So the Prime Minister speaks about the applicants. He speaks about himself as the leader of the JLP, Prime Minister of Jamaica. The second applicant, Imperium, he says he is the sole director and shareholder of Imperium, which is a holding company that holds property and assets. He speaks about the third applicant, Positive Media Solutions Limited, which is a company of which the shareholders in Positive Media were Mark Azan and Imperium. Positive Media, he says, is a company he uses to manage his intellectual property and image rights. It also rents media equipment. The fourth applicant, Positive Jamaica Foundation, he says this is a company limited by guarantee without share capital. He says Positive Jamaica is not actively engaged in business, but he uses it to make grants or donations or to assist people who from time to time ask him for help. He says the company is not a registered charity, although he loosely says that he uses it for charity purposes. So he says the allegation that he misappropriated funds from a registered charity is false and irresponsible. He says a quick check at the Registrar of Cooperative Societies would confirm that it is not registered as a charity. He says he denies the allegation of misappropriation. And throughout the investigation, he says the allegation of misappropriation of bond proceeds was not put to him by the Director of Investigation. He says, therefore, he was not given an opportunity to respond to this allegation, which would have clarified that issue. He says this matter concerns the report from the Integrity Commission of 30th of August 2024 and the special report dated the 5th of September 2024. He says the reports are being challenged, and we'll hear more about that later. He says having read the reports, he now knows for the first time that what was referred to the Director of Investigation for investigation are as follows. His net worth, calculated based on information included on the statutory declaration for the year ended 2021, and additional information that he provided in terms of his net worth, that it grew over a 5-year period ending the end of 2021. 2 unexplained changes in net worth, and 3, although his net worth appeared to align with income for some years, the growth of the net assets of companies for which he and close family members are majority shareholders, and the actual contributions of minority shareholders. So the Prime Minister is saying that it's when he read the report that he knew for the first time that this was what was being investigated. He says he was not asked any questions about the matter in the first and second bullet points. I'll just read it as it is here, although, as I said, I think there is an error there, as a notice of interview and attachments will show. He said the statement that his refusal to provide the Director of Investigation with a breakdown of expenses for the period covered by the investigation, and that hindered him in the investigation, he said that statement was false for the following reasons. A. He was not asked to provide any income and expense statements for 2019 and 2020. B. He says he was not referred for financial investigation pursuant to the Integrity Commission Act. C. He said only the 2021 declaration was referred to the Director of Investigation for investigation. D. He says the report shows he had already arrived at a negative net worth for 2021 and 2022 for him, Mr. Holness, which would not necessitate an inquiry into his income and expenses. He says it was only after what he calls the improper combination of his assets with the company Imperium's assets that the Director arrived at the sum of 1.9 million, which he said was unexplained. He said he's been reliably informed by his attorneys and he believes that this sum would not trigger an explanation, meaning would not require him, Mr. Holness, to make an explanation under Section 14.5 of the Corruption Prevention Act. So he is saying here that his lawyers have told him that this sum would not require him to explain how he came by this under the illicit enrichment section. He's also saying that his attorneys have told him and that he believes that the Director of Investigation collected evidence, analyzed it, made findings of fact while combining the roles of investigator, prosecutor, and judge. He says, moreover, the section under which the Director of Investigation was proceeding places a burden on him, Mr. Holness, to prove an essential element of the offense of illicit enrichment, that is a wealth element, meaning under this particular section of the Act, if a public officer is asked how they came by a particular asset, they have to prove that they did so lawfully. Mr. Holness says in his affidavit that the problem is compounded by the fact that the respondents, meaning the directors and the Integrity Commission, already had the sum he was required to explain, but did not disclose it to him so he could adequately respond or cause representations to be made on his behalf to resolve the matter. He says he's also been reliably informed by his attorneys, and he believes that the contents of the report, that's the investigation report that was sent to Parliament, he said this report disclosed personal and private information of the applicants, as him and the three companies, in breach of privacy and the data protection laws of Jamaica. He said what was disclosed was more than what was necessary to make the report to Parliament. He said he was asked questions in a vacuum. He said he was only provided with the documents listed in the appendix later on. He said the Integrity Commission Act provides for confidentiality of the proceedings as well as the excision of prejudicial material if there is a finding of corruption or an offence under the Act. So he's saying the Act does make provision for some matters not to be released to the public. He says the objections I put forward were dismissed without a hearing, and he says this was improper given the substantial nature of the objections that in some cases went to the respondent's jurisdiction, meaning that some of his objections were saying that the Integrity Commission and the directors didn't have any basis, any lawful basis for the kind of investigations they were trying to do. He said, in addition, he has a right to privacy. He said the Director of Investigation and the Integrity Commission deliberately ignored his objections through his lawyers and published a report imputing criminal and unethical conduct to him and to the three companies. He says the report raises a number of issues concerning natural justice / procedural fairness, breach of his constitutional rights, and illegal and ultra-vires conduct of the Commission and its directors of investigation, the Director of Investigation and Director of Information and Complaints. Ultra-vires conduct means that the person or the entity is acting outside of what the law allows them to do. And he says because of these issues that he's raising, the reports that were sent to Parliament are tainted and ought to be struck down. Okay, then he gives details of some of what he is saying happened. He's saying the Director of Investigation and the Integrity Commission acted ultra-vires outside their lawful authority, illegally and unfairly in carrying out their statutory duty, meaning their duty under the law. The Integrity Commission Act, that's a statute, so your duty under the statute is your statutory duty. And he said they acted ultra-vires, illegally and unfairly, having regard to the referral set out on page 4, paragraph 1.1 of the report. He said the directors and the commission knew that the commission did not make the referral. He said they knew that the three companies were not notified of the referral, or in any case that the information they had didn't rise to the level that required explanation by him, Mr. Holness, as it was acknowledged that his net worth appeared to align with his income, so any investigation on the basis of illicit enrichment did not arise. And just to say, the referral they're talking about, when the Integrity Commission wants the Director of Investigation to look further into something, they make a referral to him for investigation, all right? Or the Director of Complaints and Information can also make a referral. He goes on to say that the directors and the commission knew that the alleged unexplained sum for the year ending December 2021 was only 4.4 million, but this was never disclosed, he said, to him for an explanation as required for an investigation for illicit enrichment to start. He said also there's no statement that this was a disproportionate sum. He said the directors and the commission knew that the ultimate objective of the investigation was to trawl through the three companies' private information, but they didn't notify them and made adverse findings without hearing from them. He says the directors and the commission only asked questions about the companies and business associates, but asked nothing about the substance of an investigation for illicit enrichment. He says it's therefore improper to suggest that he, Mr. Holness, was the reason that prevented them from completing their investigation, as they had the alleged figure that needed explanation from the outset. They never disclosed it to him, and he said they now want to continue their illegal quest by pretending that he withheld information and improperly communicating it in a manner that they knew would attract public odium and cause prejudice to him. So he's saying that the directors and the commission didn't tell him essentially exactly what was being investigated, and they have now put it out into the public in a way that is turning the public against him. That's what that's saying. Mr. Holness says as a parliamentarian, he knows he's required to file an annual declaration each year, and he says he has complied with this. He has done this, he said, and filed his declaration for 2021. He did that on the 29th of March, 2022. He says over the period 1997 to 2020, he submitted his statutory declarations as required, and they have been certified and are published. He said he submitted his statutory declaration for the 2021 year within the time required. He said he was called in and he met with the Director of Investigation as the declaration had been referred to him for investigation. He was asked to submit an amended statutory declaration. He said after that, the investigation was closed on the 19th of February 2023. But he says nothing was published exonerating him, and he was not asked to exercise his right to refuse publication of exoneration. He said he only knew about that right because of his lawyers advising him. He said on or about the 26th of April 2024, he got a letter from the Director of Information and Complaints. In that letter, he was told that the Integrity Commission had examined his 2021 declaration as well as the other information provided and said the matter would be escalated. He said he was surprised by the letter because he had responded to all the inquiries and he hadn't been asked to clarify anything following his answers. He said after that he got a letter from the Director of Investigation who said his declaration had been referred to him by the Director of Information and Complaints on behalf of the Integrity Commission. He said on getting that letter, he became even more concerned, so he hired lawyers, Henlin, Gibson, Henlin, to represent him. He said an inquiry was made as to the basis of the referral for investigation, and he was told by the Director of Investigation that new matters had arisen. He said to date, he had not been advised what those new matters are, and he said he had asked through his attorneys, and he had also observed that he was being asked for the most part the same questions he was asked before the first investigation. He said he was advised by his attorneys and he believes that if the Director of Information and Complaints believes that the statutory declaration is to be sent for investigation, it must be provided for further and necessary action, and that is supposed to include a consideration and a decision. He believes he's entitled to be heard on the matters of concern or that would trigger an investigation. He says his concern in this case is that this matter was referred to investigation without reference to the Commission for further and necessary action, including consideration and a decision. And because of that, he wrote to the Chairman of the Commission to express his concern, to ask what the new matters were. He said the Chairman responded but didn't give a direct response to the objections and concerns raised. He only indicated that the Director of Information and Complaints had fully complied with the law. He said there was no statement on whether the Integrity Commission had complied with the Integrity Commission Act, which was one of the primary concerns that he had raised. He said he specifically asked his lawyers to direct that inquiry to the Integrity Commission. He said his attorneys responded saying the Commission had not responded to those substantive concerns. He said to date, they have not received a response from the Integrity Commission on these issues, even though they requested a proper and considered response. He says he later got a letter from the Director of Investigation suggesting dates for a meeting to conduct an interview. Between the 4th of August 2023 and the 16th of August 2023, his lawyers and the Director of Investigation were trying to fix a date for the meeting. He said on the 17th of August 2023, he was asked by a journalist about his ministers and investigation for illicit enrichment. He responded in the negative. This is where the Prime Minister had told journalists that he had asked far and wide and didn't know which parliamentarians were being investigated for illicit enrichment. He said his lawyers were sent an email on the evening of the 18th of August 2023 with a letter from the Director of Investigation enclosing a notice of interview, the judge's rules, and a document entitled Areas for Interview, as well as an appendix with his bank statements and his investment statements. He says the email was copied to him, but he hadn't seen it on the 18th of August because he was overseas on business. He said he was told about it days later and hard copies delivered to his lawyers on the 21st of August 2023, and it was agreed that they would deal with them. Based on the notice and the documents, he said he understood that they were now treating the investigation as one for illicit enrichment, that they would ask questions about his bank accounts, his investment accounts, which required explanation, about business associations and investments, and about funding of liabilities associated with business activities. He said that apart from the statement in the notice about illicit enrichment at the top of the notice, he was not given a figure that required explanation, and he was not asked about his income and liabilities as set out in the declaration. He said he should have been told the sum that is considered disproportionate. So he said his lawyers spoke to the Director of Investigation. Their concerns were the scope of the investigation. In other words, how wide it was. They felt it was too wide, clearly. He said another concern was an obvious error in the conflation of corporate and personal assets. He said there was no clear statement of the basis for concluding that his assets were disproportionate to his lawful income. He said there was no statement identifying the assets owned by him by classification and or value, or a statement or evidence setting out the assets or the amount by which his assets disproportionately exceeded his lawful earnings. And another concern was a failure to afford him with the precise terms, nature, and basis of the allegations against him to enable him to respond accurately to the allegations and the statement he was being treated as a suspect. Now, the Prime Minister goes on after that to speak about the companies and ADMAT, which is the company that had been incorporated in St. Lucia, that he had wound up, and he had transferred its assets to Imperium, which is a company you're now hearing a lot about. So we're going to talk about that when I pick up in the next video. I'm going to leave it there for today. Thank you so much for joining me courtside. I'm Dionne Jackson Miller.